So I've been asked to give you an overview of IP and protecting your innovation. So just before I delve into the world of IP, I'll give you a little slide overview on Medipex, the company that I work for. So Medipex is a healthcare innovation hub. We were established by the Department of Health and spun out of the NHS in 2002. We're a not-for-profit SME. We're a very small SME. There's only 7 of us. And we've been independent of the NHS since 2009. We work with NHS organisations. We're a membership scheme. So we have the NHS trusts are members of Medipex, and we provide support on innovation and translation. And we also work with, is this a laser pointer? No. We also work with universities and medtech SMEs. So we provide those organisations with support with recognising and identifying intellectual property. We do work on understanding market opportunities, validating clinical needs, and we map out product development pathways and help them with the commercialisation if that's the right route to take the technology or the development. So Phil mentioned about the innovation pathway. This slide gives you an overview of the innovation pathway from identifying the unmet need, taking it through the various stages, hopefully to commercialization and use in the clinic. So today I'm going to concentrate on one of these important steps in this innovation pathway, and that's making sure that you protect any new IP that you develop as part of that innovation and translation. So what is intellectual property? Well, it's basically anything that's created by a person, a creation of the mind. So it can be inventions, it could be literary, artistic works, designs, symbols, names, and images. And all these images at the side here, these are all part of the IP world. They're all types of IP, and there's some examples of IP here that there can be new, improved medical devices, software, diagnostics, and testing, training courses, and so on, including therapeutics. So this is all intellectual property, and it's all things that can be protected. So why is protecting IP important? Well, essentially it prevents others from copying your ideas. It takes a lot of time and effort to develop new medical technologies. So you want to make sure that your ideas aren't taken by others and they're not benefiting from your hard work. You can retain control on how other people can use your developments, and you can get acknowledgement and credit for your organization and yourself. Intellectual property has a value. It's a bit like property. It can be bought and sold, so it can generate income. And also IP can increase the value if you're a company or you're thinking of spinning out and developing a company, that can increase the value of your organization. So like I said, your colleagues in your organization have spent time, resources, intellect, and effort into developing the idea. And protecting your IP ensures that you lock in value and the potential rewards from all the effort that you've made. So these are the different types of intellectual property. At the top, you can see patents, and that's what a lot of people will automatically think of. When you mention IP, they think, oh, you're talking about patents. But IP is much broader than that. You have design rights, which protects how things look, and you know, the way that a product can be used. That's protected by design rights. Trademarks is obviously you protect your brand name. If you were setting up a new company, you would protect the name of that company. You would also protect the name of any products that you're developing. Know-how, well, that's a bit like the Coca-Cola secret recipe. That's it. Trade secrets, that's protecting your intellectual property using confidentiality and making sure that it doesn't go outside of the company. And then there's also copyright, which is generally used for literary, so written pieces of work, artistic pieces of work, and software. And in the next slide, I'm going to give you more information on copyright. So copyright is an unregistered right that happens automatically. As soon as the written work or the artistic work is created, you have the copyright on your piece of work. It arises automatically, and it lasts for 70 years after the death of the author. So it's quite a strong way of protecting your IP. And these are the things that can be protected through copyright. So like I said, written works, diagrams, photographs, broadcasts. It's quite a broad range of creations of the mind that can be protected. And it's an automatic right, and the way that you would protect your copyright is by putting a copyright statement. And if you look at the bottom corner of the screen, you'll see that we have a copyright Medipex, and that's how you would if you put that onto your piece of work, that provides notification that this is copyrighted. So on to patents. I'm not going to go through all of the different types of IP. I'm just going to concentrate on copyright and patents. So a patent protects how something works, how something is made, and what something is made of. And it's basically, a patent is a deal between the state and the inventor. And the inventor agrees to publicly share the scientific and technological advancement for the benefit of society, and the state promises in return that the inventor will be protected from other people using their innovation for a period of time, which is usually 20 years. Patents are territorial. When you're watching Dragon's Den on the TV and people say they have a worldwide patent, worldwide patents don't exist. They've probably put a patent application and it's patent pending. So you have to protect your innovation in every territory where you think that your innovation will be marketed and sold, and that can be extremely expensive. So the biggest tip about protecting your IP, and if you feel like you should be going towards protecting it through a patent, is you must keep it completely confidential until you've filed the patent. So filing a patent, it can be a complicated process, but what can you patent? It must be novel, so it must be new. No one else has invented it previously. It must be inventive, so there must be that inventive step. It can't be just an improvement on something that you've already done, and it must have utility, so it must have a use. And it can't be theoretical. You must have shown that it can be exemplified in the real world. So one of the first things that you want to do if you feel as though you've invented something, you're interested in protecting it through a patent, is to carry out a patent search to look at the prior art, which means the existing patents and IP that are out there. So you would generally do a search using an online tool, and you would check that there's no other patents that would affect your freedom to operate, so that you wouldn't infringe on those other patents that are already published. And essentially, I think the biggest advice here is, if you're interested in getting protecting your IP through patenting, make sure that you work with a patent attorney. They're trained to make sure that those patents are robust and protect you to protect your technology to the best it can be. Cost for filing a patent is usually about £5,000 to £6,000, and that's for the drafting and filing. And there's this scheme at the bottom that shows you the rough time scales. So from filing, you would go to PCT, which is a patent cooperation treaty, which allows you to decide which countries that fall under that treaty where you can protect your technology in. And then 6 months after the PCT stage, you would go to the publish, and then 30 months after the initial filing, you'd go to a national phase, and that's when it can be an expensive business to protect your technology. You have to choose the territories that you want to protect your technology in, and that's, like I say, it can cost a considerable amount of money there. So practical considerations for protecting your IP. We've talked about confidentiality. You must not disclose your inventions or your novel ideas to others outside your organization. unless you set up and work under some sort of agreement. So these, you've probably heard of these, confidentiality agreements, non-disclosure agreements, but also collaboration agreements and fee-for-service agreements if you wish to work with external organizations while retaining that confidentiality and novelty on your invention. Those agreements allow you to work with others under the confidentiality described in those agreements. As part of those agreements, you would have clauses in those that would allow you to manage the IP. So if you're working with others and there's two parties coming together to that have IP and bringing those IP together to work together and develop a product, you would describe the background IP, which is existing patents that are coming together to under that piece of work. And you would have a plan for managing any new IP, so that's the foreground IP, any new IP that comes out of working with these parties. And if you're a company or you're thinking about spinning out a company, you want to think about an IP strategy, and that's looking at all the different ways you could protect your company, like I said before, through trademarks, patents, etc. Am I running out of time? I'm nearly finished. So useful resources. The US Patent Office, the UK Intellectual Property Office, and the EU Patent Office have really good online resources. The patent search tools that I talked about, the free ones available are Espasnet, which covers the EU, the US Patent Public Search, and then Google Patents is also a good means of doing patent searches. Just a final slide. I used to work at the Medical Technologies Innovation and Knowledge Centre, which is part of the University of Leeds. As part of that EPSRC-funded program, we developed an academic's guide to medical translation, medtech translation. Although it says academics, it's a really useful online resource that covers all the processes in the innovation pathway. And it has got a useful section on protecting your IP and the steps you need to take. And I think that's it. Thank you very much.